All right, so welcome back to Law and Crypto. My name is William Krause. I'm an attorney focusing on governmental investigations and other disputes related to digital assets and blockchain technology. Last week, we discussed the Uniswap class action complaint, and I told you some of the things it might mean for the crypto industry. And specifically, I said that I was also interested in a few things from a legal perspective, such as what the court was going to do with the allegation that a handful of low-cap tokens purchased by plaintiff were securities, and what was going to happen to plaintiffs' Section 12A1 claim under the Exchange Act that Uniswap was selling unregistered securities. Now, like I said last week, I thought these two things were really interesting because they have the ability to kind of change how companies selling digital assets like DEXs in the United States, do business, interact with US customers, and could actually create some new precedent around what tokens are deemed securities in the United States. On that last point, one of the comments to that video asked if we might be able to do an overview at some point is to basically, spell out the framework or the securities framework for trying to determine whether a token might be considered a security under US law. And that's what I'm going to focus on for this week's episode. So with that, let's go back a ways. So notwithstanding the technology at issue and, sort of how cutting edge everything is right now, SEC has traditionally looked to a 1946 Supreme Court case called SEC versus W.J. Howie, or the Howie Test, as it'll become known, to determine whether a digital asset should be considered an investment contract, which is a type of security, as opposed to another instrument, like, say, a commodity. So I'm going to pull up my first slide here. Bear with me as always. All right, so hopefully you can see this arch here for, Howie in the Hills entrance. So who is Howie? Well, W.J. Howie owned orange groves in Florida. And one day Howie decided that he was going to sell contracts on some of his groves to tourists, and how he would tend the land, he would harvest, he would market the produce, and the purchasers of the contracts were promised essentially a share of the profits. Now, there's a bit more to the story, and fun fact, there's actually a town that's still named Howie in the Hills somewhere outside of Orlando. Kind of a colorful guy if you dig in and read about his background. But Howie didn't register with the SEC, and just like they do today, the SEC obtained an injunction regarding the sale. And the case went all the way to the U.S. Supreme Court. Now, at bottom, the question presented by Howie was whether the offer of an investment in a citrus grove with profits to be derived from the work of the owner/seller constituted an investment contract. Like I said, that gave rise to what's commonly known as the Howie Test. And if you've been in the space for a while, or you pay attention to the legal side of crypto at all, you will definitely heard of the Howie Test. And you can construe it as either a 3 or 4-part analysis, but I like to think of it as 4 parts. Investment of money, it's 1. 2, in a common enterprise. 3, with a reasonable expectation of profit. 4, derived from the entrepreneurial or managerial efforts of others. And there's all sorts of different ways you can construct these various parts, I think Howie actually says solely from the efforts of others. This entrepreneurial managerial effort, I think, kind of came in later, and I like to, use that one. But, if the elements generally are satisfied, then you probably have an investment contract and hence a security under the Howie Test. Now, the SEC has applied this analysis to digital assets a few times. Put up another screen here. I'll show you what I'm talking about. They've actually given us some pretty good guidance over the years. So I'll share. All right. So, here's one of the sort of key pieces of guidance. So this is called the Dow Report, the report investigation pursuant to Section 21, the Dow. And this really sort of talks about, the Dow token. And it was sort of, applying the Howie analysis in depth and walking through the various parts of it. And really the SEC sort of showing its work here, which was really helpful. And people kind of still look to this, as well as some other stuff I'm going to mention. Like, for instance, the SEC also published this in 2019, the framework for investment contract analysis of digital assets, and that provided a great deal of clarity here as well. A few key takeaways from this document. Whether a particular digital asset is going to satisfy the Howie test is going to depend on a lot of different considerations and facts. It also found that the first 2 prongs, the investment of money and a common enterprise, are usually going to be met with digital assets. And really where the challenge is and sort of the facts come in a lot is, trying to figure out this sort of third and fourth, or as the investment framework only treats as one prong, the reasonable expectation of profits derived from the efforts of others. And, the framework gives some pretty good detail here. I mean, it talks about, different sort of aspects, burning, buyback, whether the developers can continue to do stuff after the project's launch, things that are actually applicable in the real world to tokens. So, if you really want to dig into it, the framework provides a great jumping off point to sort of see what the analysis might look like in a number of real world situations. I mean, and to sort of recap and avoid any doubt here, I mean, the question of whether a given digital asset constitutes a security is really, really a specific, highly specific legal and factual inquiry. And to quote the SEC once more, it's going to depend on the facts and circumstances, including the economic realities of the transaction. So that out of the way, let's walk through, a hypothetical analysis. So is there going to be an investment in money in your given token? In almost every case, like the framework says, yes. Obviously, this is going to be met where cash is being paid, but to be clear, even though Howie used the term money, it doesn't really need to take the form of cash. In fact, the courts have sort of said that contributions or investments, among other things, will count. So in almost every case with crypto, if it's like someone swapping ETH or some ERC20 coin on a decentralized exchange or otherwise purchasing or investing, you're probably going to find that this first prong, the investment of money part, is satisfied. All right, so that's part one. So part two, is it a common enterprise? Well, this can be a little bit more tricky, but again, in the eyes of the SEC, this is almost always going to be met. And there's a couple different ways of looking at it from a legal perspective. Generally, though, at a very high level, it's just talking about whether there's a group of people sort of working together for the success of the investment. And there's more or less two ways you can look at this, right? So the most common, or sort of the main ways that courts have interpreted this over the years are, either vertical or horizontal commonality, or in some cases both. And, to explain that a little bit, I mean, just think about what the first word is. Horizontal means side to side, vertical means up down. So what's vertical commonality? It basically means that the success of the investment is going to depend on what the promoter or the person behind the investment does. So you can think of this as a vertical relationship, right? Like you got the seller up here, you've got the investor down here. And within that, there's even more sort of ways of looking at it. Courts have, said we're going to look for broad vertical commonality, which really just means that the investor's success needs to only be tied to the efforts of the promoter, or strict vertical commonality, which is sort of a higher standard, which says that the investor's success needs to be tied to the promoter's actual success. On the other hand, you have vertical commonality. So if you've got your issuer up here, your promoter up here, and you've got your investor down here, if you go side to side from there, that's going to be your other investor. So that's horizontal commonality. There basically courts say that the prong is met if any individual investor's fortune is tied to the other investors. And that's the horizontal aspect, like I said, side to side. So let's recap real quick. Traditional analysis, we've got these four parts, maybe three, depending on how you roll together the last two. Investment of money, almost always going to be met in crypto. Two, in a common enterprise, again, basically people sort of pooled together, their fortunes are rising and falling together, whether it's between the investor and vertically up, the promoter, or the investor horizontally side to side, the other investors. Now we have to talk about parts 3 and 4. So with parts 3 and 4, and here we go back here, we've got a sort of reasonable expectation of profit. And in a lot of cases, the answer is going to be yes. And we've seen this all before, right? So there will be, there'll be the coin that will come out, and, we've all heard that pitch, and it says we're going to do amazing things, and, we're all about the tech, and that's it, and we're going to spread awareness, and we're like save river otters or something. And at the end of the day, and I know that really the only reason anyone's buying it is hoping that's going to 100x, right? And spoiler alert, the SEC has figured that out. Not to say there's not any sort of altruistic coins out there, or folks that are trying to do good with the tokens, but let's be honest, a lot of these are really intended to sort of make profit. So the SEC will go, and they've said before, they'll cut through all the marketing, they'll cut through the white paper and the tweets and whatever else, and they're going to try to determine what the real economic reality is of that transaction. If this is trying to make profit for somebody, then you're probably going to satisfy the third prong. So, what about a token that represents something that never is going to go up in value, like a stable coin? Where's the expectation of profit in something that's always going to be pegged to $1? And does that change when you're talking about algorithmic stables? And a lot of those are coming out now that are backed by a basket of digital assets. We're still figuring that out. In fact, that's sort of a hot button topic still. I mean, I had mentioned, I think in a previous talk that, the Stablecoin Trust Act, I believe it was called, talked about stablecoins and how they should be classified. And I think in certain circumstances, it was expressed that we are going to take this position by law that this kind of stablecoin is not a security. Let's talk about some other aspects. How about a token that really just represents voting rights? And that was Dow. What if there are dividends to be paid out? Are the voting right tokens actually supposed to go up in value for some reason? And the Dow report actually dealt with that exact issue. They found that the Dow was intended to give a return on investment and the holders stood to share in a profit of the project. But what if it is truly nonprofit? We have to sort of figure that out. And again, the framework does a pretty good job in sort of spelling that out, right? I mean, it talks about, different use cases and, what I consider like as a token consumable, does it reflect access to computing power or access to some tool? In those cases, there's less chance that there's an expectation of profit. And if any of these prongs fail to be met, then, you do not have a investment contract and then a security on your hands. So let's look to the last prong. Again, we got these sort of three things that I've construed them, and that's really whether that profit expectation was derived from the entrepreneurial or managerial efforts of others. Now, to jump back, I always think of this is related to the orange groves in Howie. There you basically have this guy who's offering investment to tourists down in Florida, and I imagine like somebody's down there and they'd say, hey, I'm Howie, I've got this great plot of land and we make these awesome oranges, everybody wants these things. And I think he actually bought the land for like $10 an acre and he was reselling these contracts for like $800 or $1,000 an acre. And, say Bob from Wisconsin shows up and he's got his family there and he's on vacation and he says, hey, this is a great orange grove. I'd love to invest here. And Bob says, here's my money. And Howie says, great, I'll take your money. I'll grow the oranges. I'll take them to the market. I'll sell them, all this other stuff. You'll just get some of the profits. And in that case, it's pretty clear that the profit was derived solely from the effort of others, right? Like, the guy from Wisconsin was going to take his piece of paper, drive home, and he wasn't going to do anything that was going to increase the value of that investment. Rather, Howie's efforts are what matter, right? That would make the orange grove profitable. And you got the same thing in crypto. I mean, the question here is really whether the promoter or the issuer is the main thing driving the profit or the substantial, cause behind the profit. It doesn't have to be the only one. But at the end of the day, if the issuer is out there on CT, crypto Twitter promoting the coin, or if you're expecting it to make money because of these, great team or the great devs, or the deal they're trying to set up or who they're lined up with, it's more likely going to be satisfied. And sometimes the court or the SEC will look at it a different way. They might actually say like, what would happen if the issuer or promoter stopped working right now? Would the coin keep doing its thing or the project fail? To that end, I think I mentioned before, what the developers do after the coin is issued is really going to be important too. I mean, if they just go and they make, they mint their 420 quadrillion coins, they put it out on the market and they walk away, well, that's one thing. But, if you've got a program or a token that's, they're developing new stuff, they're having, conferences, everybody's looking at the token and trying to get a part of it, and you got business partnerships, all that stuff. But it's like sort of this ongoing effort. Well, that's a different story. So I'm not saying that wouldn't necessarily make it a security, but we've got these prongs, right? And if you get all of them satisfied, that is generally the test for an investment contract. And I'll digress for a second. I mean, this is part of the reason why you never hear Bitcoin referred to as security. There's no team out there working to sort of promote Bitcoin on the back end. Or line up, the next big sailor purchase or something like that. And in fact, back in 2018, the chair of the SEC said that Bitcoin was not a security. And, that's just hasn't said that for a lot of coins. And that makes it really unique. Bitcoin sort of lacks this sort of continual, managerial effort in the background. Like there's no like Bitcoin Corp who's going and improving the tech like every day. And I'm not making light of the people who work and, mine and do stuff to make Bitcoin better, but they're sort of like released, right, and given to us all. So from a securities perspective, that actually is interesting. Kind of Bitcoin in one bucket as opposed to all these later coins that come along, with foundations or whatever, and they're sort of trying to, market this product. So let's recap. you basically have these four prongs, three depending on who's constructing it, but it comes down to an investment of money in a common enterprise with a reasonable expectation of profit derived from the entrepreneurial or managerial efforts of others. So how do we know if our coin qualifies? Well, it's complicated. That's basically sort of the crux of the analysis, but it's going to be informed by the guides that's come out, like the Dow, like the investment contract framework of 2019, like, subsequent cases. And that was part of the point I was making with Uniswap. If the judge in that case comes out and says, on these allegations, exactly as plaintiff has said it, which, that complaint was a lot of talking about promotion and marketing, and not so much, the back end of the organization. But if they say that's enough, then that's going to be telling, right? That might mean that it's a lot easier to plead that a coin is a security. On the other hand, if they say, no, you failed, or, there wasn't a reasonable expectation of profit for this reason, and that also moves the needle. And that's part of the thing that's really cool about crypto law right now. There's always cool about crypto law is, this isn't like trust and estates law where people have been doing this for 150, 200 years, and it's like changing very slowly. Every case that comes out that touches on this analysis, has the opportunity to sort of move the needle a little bit. So, you have to go, and if you're going to try to figure out if your token meets that test, you're going to have to try to interpret it or get a lawyer to try to do the assessment and say, yep, probably is a security, or no, it's not. And, there's a lot of them out there, a lot of coins out there that are, probably securities, to be honest. And, some of the time you get that guidance from the SEC or a court, and they definitively say, coin A or coin B is a security, and that might clear it up a bit. And in fact, when that happens, you sort of see this reaction from businesses because, well, it's this big gray area for, 95, 98% of coins out there because nobody sort of definitively said they're securities. If somebody says, that coin, the Kraus coin or whatever, that's a security. And then boom, you find that US businesses start delisting it. They sort of have to treat it differently. So they're not accused of sort of knowingly selling an unregistered security. And sometimes you can actually go to the SEC and you can ask them. It's not really a firm answer that they give you per se, but you get what's called like a no action letter. And that basically is the SEC saying, you've presented these facts to us, you've told us all about your token, and then based on these facts and exactly these facts, we will not recommend enforcement action, which is kind of like, it's not the same as saying, it's not a security. It's just like, we're not probably going to investigate you over this. And I think they've done that twice. I just put up one example here. Bear with me. There was a case called Turnkey Jet, no action letter called Turnkey Jet right here. And, the SEC sort of talks about it. Important will sell tokens at a price of $1 per token. So there's that lack where there's no expectation of profit. It's also important that it was an internal token. And I think that's another thing to keep in mind. There's like this big difference between sort of centralized and decentralized blockchain and, tokens that are like used within a company and ones which are sold on the secondary market, right? And what that might mean for the expectation of profit. And it's sort of at a very, very high level. And this thing is one page, spells out, the ruling and sort of the reasoning there. So that's one. I think there's another one called Pocketful of Quarters. Both of those, if I recall, did have fixed US dollar value. So, they were sort of pretty good on that reasonable expectation of profit part. So what about the thousands and thousands and thousands of other tokens I talked about in the gray area? Well, again, each one's different. I'm not going to say that, all of these are security or none of them are or whatever, because it's a really fact-dependent analysis, and you shouldn't sort of make these broad categorizations because each token might be different. But I will tell you that absolutely, let's be honest here, there are unregistered securities out there, and the SEC can, and more likely than not will, bring enforcement actions against some of them. And was an enforcement action, this could be a whole subject for another talk. That really just means the SEC will investigate confidentially. They'll send, a subpoena. They'll say, we're going to look into this, this, and this, for potential violations. And it'll be sort of fact gathering, discovery. Again, a lot of this is sort of confidential. And then ultimately they will either, move to take the case to court, or more often than not, they will settle. And then when that happens, you sort of see these letters come out, and, it's sort of a joint cease and desist, an order, an assessment of a fine, and then at the same time, it's sort of a settlement. So they announce the charges at the exact same time that they announce the settlement. And that's usually when the public finds out for sure. the SEC or CFTC or whoever was investigating. So, will the SEC go after them all? No, realistically, they won't. And I say realistically because that's just, sort of a matter of assessing resources, right? I mean, the SEC is like any other agency. It's like, the police or whatever. It's like, if there are, all these different things out there that are potentially problematic. I mean, the SEC is not going to be able to go and file 10,000 lawsuits at once and have the lawyers to staff that and to, take those to conclusion. So they will more often than not sort of go after, the symbolic, the large coin, or the large sort of problem that's going to make a difference. And we've seen this before. In 2017, there was sort of the ICO craze, and a lot of people were getting harmed. I mean, realistically, like investors were losing their money. You're having these flashy sort of websites. And I think even now, I don't have time to pull it up, but if you go to like Howie Coin, like search Howie Coin in Google, the SEC actually had this website set up for a long time. It was like a sham website, and it showed like, a picture of the Bahamas, and it was like, oh, invest now in yachts and all this cool stuff. And I mean, it was an example of the kind of promotion that ICO issues were doing in 2017 to lure people in, and their sort of silver token and their gold, offering and their ICO countdown and all that stuff. I mean, we've seen that before. We've been in crypto. But the point is, folks are losing money. Investors were really getting harmed. So the SEC focused on the ICOs for a while, and they made a number of sort of flashy, enforcement actions and settlements. And, true to form, the market kind of walked away from ICOs. I mean, they still go on, yeah, but to hear about ICOs going on in the United States is pretty rare. And when they do still happen, they're usually met with a cease and desist or an injunction right away, because the SEC is sort of taken a position that we are inherently skeptical about ICOs, and so much as more likely than not they're securities, and that's an unregistered securities offering. So, and that's really what we got right now. I mean, we sort of have the sense to whether something may or may not be a security, and the SEC has given us some good guidance to look to. But as people get more and more creative with the technology and start doing cool stuff with it and unusual applications, it might be tough to make that analysis, because what we saw in crypto 3-4 years ago, we might not be seeing now. I mean, what about NFTs? What about stuff in the metaverse or Web3? And as the sort of products or the tokens and the technology and the digital assets get more exotic, it becomes, more challenging to sort of make that call. So it's going to keep evolving, just like all things with the law, and particularly crypto law. That said, I think no matter what, this is an area where people still need to tread very carefully. And needless to say, you don't want to get it wrong, right? You do not want to be the one who is associated with a project or issuing a token, and then boom, it turns out the SEC is popping up and saying, hey, nice security you got there, looks like you didn't register it. And that's what I got for you today. I hope you enjoyed my fourth talk. Feel free to leave your thoughts in the comments below, and I'll talk to you again soon. All right, thanks.